Section 138, Qualification of an auditor. 1. A person is qualified for appointment as an auditor of a private or public company, if that person is a. Qualified and licensed in accordance with the Chartered Accountants Act, 1963, Act 170. And b. Not disqualified under subsection 2. 2. A person is disqualified for appointment as an auditor, if that person is a. An officer of the company or of an associated company. B. A partner of, or in the employment of, an officer of the company or of an associated company. C. An infant. D. Found by a court of competent jurisdiction to be a person of unsound mind. E. A body corporate, except that a member of an incorporated partnership may be appointed in the manner provided by subsection 2 of Section 139. F. One in respect of whom an order has been made under Section 177 so long as the order remains in force unless leave to act as an auditor of the company concerned has been granted by the court in accordance with that section. G. An undischarged bankrupt, unless that person has been granted leave to act as an auditor of the company concerned by the court by which the adjudication as bankrupt was made. Or H. For the time being disqualified from acting as an auditor of a company by order of the registrar under subsection 4. 3. Paragraph B of subsection 2 does not disqualify a person from being appointed as an auditor by reason only of the fact that that person is a partner or in the employment of a person acting as company secretary of the company or of an associated company. 4. The registrar may, subject to a legislative instrument, disqualify a person otherwise qualified from acting as an auditor of a company and may at any time remove that disqualification. 5. A person aggrieved by a decision of the registrar under subsection 4 has a right to appeal to the court. 6. A person not qualified for appointment as an auditor who acts as an auditor commits an offense and is liable on summary conviction to a fine of not less than 325 penalty units and not more than 750 penalty units, and the company by whom that person is appointed and an officer of that company that is in default are liable each to pay to the registrar an administrative penalty of 750 penalty units. Section 139, Appointment of an auditor. 1. A person shall not be appointed as an auditor of a company unless that person A. has, before the appointment, consented in writing to be appointed, and B. is duly qualified in accordance with Section 138. 2. A partnership firm may be appointed, in the name of the firm, as an auditor of a company, but, whether or not that firm is a body corporate, the appointment shall be deemed to be an appointment of the partners of the firm who, at the time of the appointment, are duly qualified. 3. Despite a contrary provision in the constitution of a company, an auditor shall be appointed by ordinary resolution of the company and not otherwise. 4. For the purposes of subsection 3. A. The directors may appoint the first auditors of a company and may fill a casual vacancy in the office of auditor, or B. If a company does not have an auditor for a continuous period of 3 months, the registrar may appoint an auditor for that company. 5. An existing auditor shall continue in office until A. That auditor ceases to be qualified for appointment. B. That auditor resigns from office by notice in writing to the company. C. An ordinary resolution is duly passed at an annual general meeting in accordance with Section 141 removing that auditor from office or appointing any other person in place of that auditor as from the conclusion of the annual general meeting. Or D. The tenure of the auditor ends, and when a casual vacancy occurs in the office of the auditor, the surviving or continuing auditor may act. 6. Within 14 days after the occurrence of a change in the auditors of a company, the company shall give notice of the change in the prescribed form to the registrar for registration. 7. For the purposes of subsection 6. A. Where a partnership firm has been appointed auditor in the name of the firm, the name and business address of the firm shall be given to the registrar. And B. A change in the constitution of the firm or of the partners in the firm with respect to an auditor of the company is not a change in the auditors. 8. Before accepting the appointment as an auditor of a company, the auditor shall communicate with the retiring auditor and request the retiring auditor to make any representations and supply information about the company. 9. The retiring auditor shall respond to the request and supply the requisite information. 10. Where a company contravenes a provision of this section or describes as auditor of the company a person who has not been duly appointed, the company and an officer of the company that is in default are liable each to pay to the registrar an administrative penalty of 250 penalty units. 11. An auditor shall hold office for a term of not more than 6 years and is eligible for appointment after a cooling-off period of not less than 6 years. Section 140. Remuneration of an auditor. 1. The remuneration of an auditor of a company shall be fixed where the auditor is appointed. A. By the directors for the period expiring at the conclusion of the next annual general meeting of the company. B. By the registrar. Or C. At a meeting of the company, by ordinary resolution of the company or in a manner that the company by ordinary resolution may determine. 2. For purposes of full disclosure, the A. Company shall clearly state in the financial statements which are accessible and reported to shareholders of the company the remuneration offered to an auditor of the company for any service rendered, and B. Remuneration payable to an auditor of the company shall be subject to confirmation by members of the company. 3. For the purposes of this section, remuneration includes the sums of money payable by a company in respect of the expenses of an auditor. 4. Where a company contravenes a provision of this section, the company and an officer of the company that is in default are liable each to pay to the registrar an administrative penalty of 250 penalty units. Section 141. Removal of an auditor. 1. A resolution to remove an auditor or to appoint any other person in the place of that auditor is not effective unless A written notice has been given to the company of the intention to pass the resolution, not less than 35 days before the general meeting at which the resolution is to be moved, and on receipt of the resolution, the company has forthwith sent a copy of the resolution to the auditor concerned. B. The resolution is passed at a general meeting of the company. And C. The company has given the members notice of the resolution at the same time and in the same manner as the company gives notice of meetings, or, if that is not practicable, has given the members notice of the resolution in the same manner as notices of meetings are required to be given not less than 21 days before the meeting. 2. For the purposes of subsection 1. A. If, after notice of the intention to move the resolution is given to the company, an annual general meeting is called for a date 35 days or less after the notice has been given to the company, the notice is properly given. And B. In the case of a resolution to remove an auditor appointed by the directors in accordance with subsection 4 of section 139 or to appoint any other person in place of an auditor so appointed, subsection 1, shall have effect with the substitution of 14 days for 35 days in paragraph A of subsection 1, and 7 days for 21 days in paragraph C of subsection 1. 3. The auditor concerned is entitled A. to be heard on the resolution at the meeting, and B. to send to the company a written statement, and the company shall send copies of the statement with every notice of the annual general meeting, or, if the statement is received too late, shall forthwith circulate to each person entitled under subparagraph F of paragraph 1 of the 8th schedule the notice of the meeting in the same manner as notices of meetings are required to be given. 4. The company is not required to send or circulate the statement under paragraph B of subsection 3A if the statement is received by the company less than 7 days before the meeting, or B if the court, on an application made by the company or any other person who claims to be aggrieved, so orders on being satisfied that the statement is unreasonably long or that the rights conferred by this section are being abused to secure needless publicity for defamatory matter, the court may order the cost of the applicant to be paid in whole or in part by the auditor although the auditor is not a party to the application. 5. Without limiting the right of the auditor to be heard orally on the resolution, the auditor may, unless the court makes an order under subsection 4, also require that the written statement by the auditor be read to the meeting. 6. If the resolution is passed, the resolution shall not take effect until the conclusion of the annual general meeting. Section 142, Functions of an Auditor. 1. An auditor of a company while acting in the performance of functions under this Act, is not an officer or agent of the company, but a. Stands in a fiduciary relationship to the members of the company as a whole, and b. Shall act in a manner that a faithful, diligent, careful, and ordinarily skillful auditor would act in the circumstances. 2. A provision, whether contained in the constitution of a company, or in a contract, or in a resolution of a company, shall not relieve an auditor from a. The duty to act in accordance with subsection 1, or b. A liability incurred as a result of a breach of that duty. 3. An auditor shall have a right of access at all times to the accounting records and financial statements and vouchers of the company and is entitled to require from the officers of the company the information and explanation that the auditor thinks necessary for the performance of the functions of the auditor. 4. The auditor of a company is entitled to a. Attend a general meeting of the company, b. Receive the notices of, and other communications relating to, a general meeting, and c. Be heard at a general meeting on any part of the business of the meeting which concerns the auditor. 5. The auditor of a company may apply to the court for directions in relation to a matter arising in connection with the performance of functions under this Act. 6. On receipt of that application, the court may give directions that the court considers just, and unless the court otherwise directs, the cost of the application shall be paid by the company. Section 143. Auditor to avoid conflict of interest. 1. An auditor of a company shall ensure that in carrying out the duties of an auditor under this part, the personal judgment of the auditor is not impaired by reason of any relationship with or interest in the company or any of the subsidiaries of the company. 2. Without limiting subsection 1, a company, person or firm that carries out duties of an auditor shall not engage in any relationship with a client that will result in a conflict of interest between that person or firm and that client, including a relationship with a client that will a. Place the person or firm in the position of auditing work of that person or firm, b. Result in that person or firm acting as management or an employee of the client, or c. Place that person or firm in a position of being an advocate for the client. 3. Subsection 2 applies to the appointment of an auditor who is appointed to perform the services of a receiver.